So today we're going to break down a really brilliant legal strategy. It's designed to fight a system that's basically stuck in the past. This is a wild story about something called ghost jobs, a battle plan that's actually rooted in psychology, and get this, how a brand new federal rule created the perfect legal trap. Okay, let's just jump right in.
First, let me ask you something. Could you actually get around in 2026 using a paper map that was printed way back in 1977? I mean, no GPS, no live traffic updates, nothing. It sounds completely absurd, right? Well, that exact absurdity is at the very heart of this entire story.
And just to really frame this, take a look at the difference. The world of 1977 had things like record shavers and typewriters. You fast forward to 2026, and we've got cloud computing and AI assistants in our pockets. This massive technology gap, well, that's the battlefield for a really high-stakes legal fight.
All right, so let's dig into this whole outdated map idea. We're going to look at how some incredibly important legal decisions today, specifically in Social Security disability hearings, are being made with data from a totally different pre-digital world.
So here's the deal. A person's ability to get crucial disability benefits in 2026 can literally come down to this government document, the Dictionary of Occupational Titles, or DOT for short. The problem? For so many of the jobs in it, the last real update was in 1977. Think about that for a second. We're talking about a world before Google even existed.
And this is where things get really weird. It leads us right into the main conflict, fighting against what are called ghost jobs. These are occupations that are still on the books, right there in that 1977 DOT, but in reality, they've pretty much vanished from the modern economy.
You know, these aren't just some abstract concept. Check out this watch list of actual relic jobs. You've got marker, a person who physically marks prices on things, a job totally replaced by barcodes. You have router, which has been made obsolete by GPS and modern logistics software, and my personal favorite, office helper, whose 1977 job description still mentions tools like record shavers. These are the specific ghosts that lawyers have to battle in court. And this is just a perfect example of how you expose how absurd it all is. I mean, imagine you're in a hearing and a lawyer asks an expert witness that question. It instantly shows how completely disconnected the official job description is from today's world. It's such a simple but devastatingly effective way to dismantle their testimony. So how do you fight something like this systematically? Well, you use a master strategy, and it's called the 1977 Obsolescence Challenge. It's this comprehensive battle plan, and it's designed specifically to dismantle any testimony that relies on these ghost jobs.
But here's the thing. This is way more than just, pointing at a calendar and saying that's old. It's a really sophisticated, two-pronged attack. It's designed to shift the whole debate and frame it around one single, powerful theme: accountability.
The entire strategy is built on two incredibly powerful metaphors. The first is called the military sponsor, which is all about strict, black and white accountability. The second is the evolutionary tribe, which grounds the whole legal argument in the very real, very human stakes of what's happening. Okay, let's break these two core metaphors down because this is where the real genius of the strategy comes in. This is what makes these abstract legal ideas feel solid, memorable, and just incredibly persuasive.
Okay, first up, the military sponsor. So picture a military base. The speed limit is 15 miles per hour, and it's strictly enforced. If you sponsor a guest onto that base and they get caught speeding, you are responsible. Period. No excuses. The battle plan takes that exact logic and applies it to the vocational expert. They are sponsoring 1977 job data into a 2026 hearing. If that data is obsolete, if it's speeding past modern reality, then that expert has to be held accountable for bringing in unreliable evidence.
Now, the second pillar is the evolutionary tribe. This one taps into a really deep, primal human fear, the fear of being cast out of your group. The argument frames the Social Security system as our modern-day protective tribe. So denying someone benefits based on a job that doesn't even exist anymore isn't just a bureaucratic decision. It's framed as a kind of unjust exile, a betrayal of the tribe's fundamental duty to protect its own members.
But wait, it gets even better. Right as this hearing is about to happen, the strategy gets a secret weapon. A real-world event unfolds that makes one of these key ghost jobs not just obsolete, but literally, legally impossible. This is the finishing move.
Look at this timeline. It shows a perfect collision course. You've got the marker job created in 77. You've got Google, which changes everything, founded in 98. Then you have the hearing on January 15, 2026. And just 5 days later, a new federal law, FSMR Rule 204, goes into full effect. The hearing is happening right in that tiny critical window.
5 days. That is the window. The timing is just incredible. It creates this huge sense of urgency and a real dramatic climax. The expert is literally on the stand talking about a job that, for all practical purposes, is about to be outlawed in its 1977 form.
And here it is, the knockout punch. This new FDA food safety rule demands digital, machine-readable codes for tracing pretty much all food. So the simple act of hand-marking items, the absolute core of that 1977 marker job, suddenly becomes a federal regulatory liability. The expert's testimony isn't just outdated anymore, it's now in direct contradiction to a federal law that's just days away.
So, what's the big takeaway from all this? Let's talk about the verdict on reality and why this incredibly clever battle plan matters so much, far beyond just this one courtroom. This quote from the closing argument just ties it all together perfectly. You hear the human stakes of the tribe, you see the absurdity of the 1977 map, and it all collides with the undeniable reality of our modern world that has been replaced by Google. It is such a powerful summary of the entire case. Ultimately, this is about so much more than winning a single case. It's a fight to make our legal and administrative systems base their decisions on the world as it actually is today, not as it was described in some government manual from before the digital age even began.
And that leaves all of us with a final, really provocative question. When a system is trying to navigate the present using a map from the distant past, who is ultimately responsible for drawing a new one?